Why have a lawyer write your will?
There's a lot of resources out there for DIY-minded folks that will help you create a fully legally binding will, whether that's good, bad, or indifferent. The companies that provide these services provide enough education to teach you what are the key components in a will. That first of all, you need to meet the formalities, the legal formalities, that it needs to be signed, dated, and you need two witnesses to your signature. If you've accomplished that and it says it's your will, you probably have a fully legally binding will, whether or not the words in it are going to match your plan. The challenges are really is that you don't get much education when you work with one of those companies. You don't really get a lot of advising or any advising on the consequences of the decisions you're making. Only a lawyer can really give you that advice. And if you're looking for it online, you're probably better served talking to a lawyer about your actual real world situation rather than just listening to me blather on about it. But there's a lot of problems that crop up when people don't really understand all the moving parts of the law here. I've seen a lot of different things like this. The biggest one is, what if there's a couple and their wills are not what we call mirror image wills? That is, that they say essentially the same thing, except the names are different. And, it's all swapped around to be mirror image of each other. The problem of not having a mirror image will is that it matters then what order two people pass in. And usually, if we think that through, it's not what folks want. Imagine this. There is a couple that's married later in life. They each have children and grandchildren of their own. Their wills say, everything to my spouse and then to my children and grandchildren. Well, that sounds really good, and that's essentially what most people's plans boil down to. But if that's what's literally written in this couple's wills, then here's the problem. One of them passes. Their estate pays out to the other. Then that person passes, and it then descends only to their descendants. The other person's descendants don't get anything by virtue of the accident of who died first. When we think about this, this is generally not what we want, that a roll of a dice is going to decide whose family benefits. But if that hasn't been thought through, the initial plan sounds very reasonable. It's also really important to understand the differences in forms of property ownership that impact how your will operates. Sometimes I see folks where it's clear that no one has talked about the difference between probate and non-probate assets. That is, there are some assets that your will say where it goes, and there's some where it won't. The ones where it won't tend to be things where there's a designation of beneficiary, like life insurance or an IRA, and different forms of joint property ownership, or things that are in entities like trusts or corporations. Everything's going to function a little bit differently. And if the implications of that haven't been explained and thought through in terms of what's actually in the will, it can have far-reaching consequences. And someone's real-world plan may look very different than what they had in mind. Circling back to the beginning, the basic problem is that wills are easy to make. Anyone can make a will with or without a lawyer. The lawyer isn't necessary to make it binding and authoritative. But if you want to make sure that what's going to really happen is what you had in mind, only a lawyer can give you that advice. I'm Josh Donovic, the owner and founder of Skylands Legal in Sparta, New Jersey. If you'd like to learn more about what we just discussed, click the link below to schedule a consultation.